Dear learners, we shall be undertaking a discussion on theories of owner shielding and entity shielding in this part 5 lecture on the kinds of business organization. Now, this lecture of theories of entity shielding and owner shielding, this is an extension of the previous lectures on the concept of limited liability and before that the concept of separate legal personality. So in this lecture principally we shall be looking at situations where the owner is protected when the company faces any financial trouble, and in entity shielding we shall be looking at situations where the company is shielded in situation where members of the company they get into financial trouble. So the word shielding refers to protection and owner refers to the members of the company and entity refers to the business organization. So the theory of owner shielding, it refers to the rules that protect the personal assets of a company's shareholders or owners from the claims of company's creditors. So this owner shielding is essentially protection of a shareholder. Now it protects what? It protects the personal assets of the shareholders against the creditors of a company. So it restricts the claim of company's creditors to assets of the company only. So it denies the company's creditors from laying a claim to the shareholders' personal assets. So it refers to the legal protection that is granted to the owners or shareholders of a company by limiting their financial responsibility to the amount that they have invested in the company. Now, situations where the theory of owner shielding may be triggered is when a company or a business organization faces financial distress or difficulty such as winding up. When at that time the assets of the company are less and its liabilities are more. So that there comes a situation as to how do you make up the remaining liabilities? How will the creditors be paid? So in that case, the company's members, they remain protected from such a situation and their personal assets remain protected. Now just to share with you an illustration or an example as to how this theory of owner shielding operates. So I have given you an example which you can read on your screen. Then based upon this example, I have posed a question before you. Now you have to undergo this exercise of reading this illustration and then trying to answer the question that is posed in the last bullet point. So in this case, there is a person named Dev who owns shares in a company. The name of the company is X, worth rupees 50,000. Now this company X falls into financial difficulties and therefore undergoes the process of winding up, which is closure. Now on the date of winding up, when the balance sheet of the company is computed, its assets are 1 lakh rupees, but its liabilities to the creditor are 5 lakh rupees. So the difference between the company's assets and its liabilities is 4 lakh rupees. Now the creditors of company X make a claim against the house of Dev to recover the debt. So their argument is that because the company is owned by Dev as a shareholder, so the assets of the shareholder, they could also be made part of the recovery proceedings against the company of which that shareholder is the owner. So the question before you is that whether in such a scenario, whether the creditors would succeed in this action or not. So going by the principle of limited liability and the theory of owner shielding, in this case the creditors of the company will not succeed because they shall be protected by the theory of owner shielding. So the theory of owner shielding, as I said, it protects the personal assets. So what are the personal assets? The house of the shareholder. Personal assets of the shareholders against the business creditors of the business of the company. So this 5 lakh is creditor which the company owes to its creditors and not individually liability of the shareholder of the company who is Dev. So because of this operation of theory of owner shielding and limited liability, in such a scenario, the shareholder remains protected. Now let us move on to the theory of entity shielding. Now the term entity shielding refers to the rules that protect a company's assets from the personal creditors of the shareholders. So the term entity here refers to a company and the word shielding refers to protection. So this theory is for protection of a company as opposed to the theory of owner shielding which is for protection of a shareholder of a company. Now this theory of entity shielding, it restricts the claim of personal creditors of the shareholders to the personal assets of the shareholders only. So it denies the shareholders' personal creditors from laying a claim to the assets of the company in which they are shareholders. So this is a protection that is given to a company against the personal creditors of the shareholders by making a clear demarcation between the personal liabilities of the shareholders and the liabilities of the business of a company. So the personal liabilities of the shareholders do not become the liabilities of the company, and in the same way the liabilities of the company do not become the personal liability of the shareholder, as we learnt in the theory of owner shielding. So the creditors of a company have priority claims over the company's assets compared to its shareholders. So in what kinds of situation the theory of entity shielding comes into action? In cases of personal financial difficulty of shareholders, such as their personal insolvency. So this theory of entity shielding may be further clarified again with the help of an illustration. We are going to do the same exercise. I have before you briefly laid the facts of a situation. Now you can read this situation. Based upon this situation, I have a question. Now, based on your reading of theory of entity shielding, you have to make an attempt to answer this question. So the illustration is that a person, Sumit, owns 100 shares of a company named Infosys Limited, valued at rupees 1000 per share. Now multiplying the number of shares with the total value of each share, His total shareholding is rupees 1 lakh. Now, total value of Infosys Limited is 1000 crore, for example, hypothetically speaking, although in reality, company Infosys Limited is valued much more than that. However, on a personal front, this shareholder Sumit, he has defaulted on a home loan from a bank, State Bank of India, of rupees 5 lakh. Now, to recover this loan, SBI makes a claim of 5 lakh rupees from Infosys Limited on the claim that since he is a part owner of a company, so therefore we are going to lay a claim on the assets of this company. So the question is that whether this claim of SBI will succeed. Now, going by the theory of entity shielding, the answer to this question is no. So the theory of entity shielding prevents the personal creditors of shareholders from laying a claim on the assets of the company. So the assets of the company will remain protected from the theory of entity shielding. So in this case, this theory of entity shielding comes to the benefit of a company if a shareholder, not in his business transactions related to the company, but in some other transactions which are entirely unrelated to the company to which he is a shareholder, he is defaulted on a loan. So in that case, because the separate legal personality of a company makes it different from the legal personality of the shareholders, so the liabilities of the individual shareholders, they remain liabilities of the individual shareholders and they are not transferred as liabilities of the company in which they are shareholders. So this is how the theory of entity shielding operates in real life scenarios and situations. Now let us briefly compare this theory of owner shielding and entity shielding. So first, what is the roots or what is the source of the two theories for owner shielding? It is related to the limited liability principle, and entity shielding, it is an extension of separate legal personality of a company. Both of these principles we have discussed in the previous lectures. Now, who benefits from these theories? Shareholder from owner shielding and company from entity shielding. In owner shielding, the company's liabilities remain the liabilities of the company and not transferred to the shareholders. In case of a company, it is vice versa. Now, who is disadvantaged in the theory of owner shielding? The business creditors, because they cannot lay a claim on the personal assets of the shareholders. In case of an entity shielding, the personal creditors of the shareholders who cannot lay a claim on the assets of the company in which they are shareholders. Now, a company may or may not have owner shielding, just like a company may or may not have limited liability. It is a choice. So it is possible that a company has unlimited liability. Under the law, a company can be incorporated with limited liability or unlimited liability. So this is optional. Whereas entity shielding is mandatory under the company law. So every company that is registered under the Companies Act, it has a separate legal personality. So the theory of owner shielding is not mandatory, and so therefore companies can exist without this theory. On the other hand, no company can exist without entity shielding, and it is not possible to register a company and the company does not have separate legal personality. So whenever a company has separate legal personality, it does get the benefit of entity shielding. Now, owner shielding can be achieved through contract, and it can also be achieved through legislation. So, for example, a company limited by shares, the definition of which we discussed, it is a statutory recognition of the theory of ownership. Otherwise, there could be a contract between the shareholders, the company, and its creditors, that if the company defaults on any loan of the creditors, then under the contract they cannot lay a claim on the personal assets of the shareholders. Whereas entity shielding, it can be achieved only through a legislation under the relevant company law. So with this, we come to the conclusion of two very important theories of owner shielding and entity shielding. So we've had an opportunity to look at the meaning of these two theories, the protective functions which they perform for shareholders and the company, the various illustrations and scenarios in which these theories apply, and lastly, what is the contrast between these two theories on many indicators of differences. So with this, we come to the closure of this short lecture on owner shielding and entity shielding. Now, a business organization, when it starts and when it gets registered in whatever form, this is a choice that the promoters of the business or founders of the business or entrepreneurs have to make as to what features do they require in a business organization. So if they depend on shareholders in order to acquire capital for running the business of the company, then owner shielding becomes important and limited liability becomes important because it is very attractive for the shareholders. However, if the promoters or entrepreneurs, they are dependent upon credit or loan for making the capital requirement of a company, then an unlimited liability company is more suitable to them. So, and ultimately, it is a choice which the business founders and promoters have to make. So, with this, we close this lecture. Now, we shall be continuing with some of the other features of company as a kind of a business organization in the upcoming next lectures. Thank you very much.